The Supreme Court, renowned for its punctuality, has reluctantly admitted that it will not meet its customary deadline for delivering its final judgments by the end of June. In an unprecedented move, the court's website was updated to inform the public that the long-awaited opinions will now be unveiled on Monday, July 1st. However, uncertainty lingers as to whether additional days will be allocated beyond that date. This official announcement merely confirmed what had already become apparent earlier in the day. Traditionally, Chief Justice John Roberts, on the eve of the penultimate opinion day, would declare it as the ultimate and final day. Yet, on this particular Thursday, Roberts refrained from making such a proclamation. Rather, he acknowledged that the scheduled release of opinions on Friday would not mark the culmination of their work, and that the court's labor would instead overflow into the following week. Typically, the court strives to adhere to its self-imposed deadline of concluding all opinions by the conclusion of June, with only recent recollections of the pandemic-induced disruptions causing any deviation from this norm. However, there is no strict obligation for the Supreme Court to adhere to its usual time frame, except for the justices' personal desires to uphold their summer plans. For instance, Justice Neil Gorsuch has a scheduled trip to Portugal to teach a 2-week course for George Mason University in the latter part of July. Nevertheless, the justices still seem to be on course to conclude their work in the near future, possibly as early as Monday, just before the court closes for the Independence Day holiday on Thursday. Currently, the court has not yet issued decisions for 8 cases that were argued, including a high-profile dispute concerning former President Trump's claims of immunity, a case that could limit the power of federal agencies, and 2 cases pertaining to social media. Ohio Republican Representative Jim Jordan faced severe criticism this week, following a U.S. Supreme Court ruling regarding a dispute between Republican-led states and the federal government's interaction with social media companies regarding contentious content on their platforms. Democratic Representative Jerry Nadler, a member of the House Judiciary Committee, expressed his expected response to the ruling, condemning Jim Jordan's extravagant conspiracy theory-driven witch hunt. Nadler's statement, shared on X, formerly Twitter, highlighted that the court's decision aligned with the testimony of numerous witnesses brought before the committee by Jordan. It emphasized that social media platforms exercise their own judgment in content moderation, debunking Jordan's claims. Nadler hoped that this embarrassing defeat would prompt Chairman Jordan and his colleagues to abandon their futile investigation into entities and individuals striving to combat the dissemination of harmful misinformation and disinformation on social media. In the case of Murphy v. Missouri, the court delivered a 6-3 ruling, with Justice Amy Coney Barrett penning the majority opinion. The ruling clarified that states and individual plaintiffs lack the standing to sue administration officials over social media platforms' content moderation decisions concerning COVID-19 misinformation. Barrett eloquently expressed that the plaintiffs are requesting us to embark on a comprehensive examination of extensive communications spanning multiple years, involving numerous federal officials from various agencies, and encompassing a wide range of topics on diverse social media platforms. However, our standing doctrine prohibits us from engaging in such broad legal oversight of the other branches